Justice and Correctional Services Minister Ronald Lamola has received 4 reports from the South African Law Reform Commission. These reports focus on sexual offences, the practice of Ukuthwala, the legal fees and laws related to prescription periods. The minister unpacked the reports during a media briefing earlier today. Well, to help us make sense of it all is Barry Bateman, my colleague, who was at that briefing earlier. Barry, good afternoon. Thank you very much for coming into the studio. So South Africa has seen recently, we've seen a number of amendments in terms of laws related to sexual exploitation of children. And, of course, the enactment of legislation such as the Cyber Crimes Act, just among several. But the Law Reform Commission has proposed legislation with greater reach. What is their recommendation?
Good afternoon, Dad. What we're seeing here, and the focus of this particular report, it related to sexual abuse of children, but also looking at in the modern context of where we sit now in the modern world with our devices and young children and the access there too, which also relates to the creation of sexually explicit material by children. And the way that the Law Reform Commission is proposing that the state or the legislation should view this particular type of, and there's a change in the name of term here. Instead of referring to child pornography, for example, now think of the word pornography, it is consenting adults creating explicit material for the consumption by consenting adults. So that term in itself it cannot reconcile with children. So child pornography is no longer going to be used. We're going to adopt the term, it is child sexual material. So it is to view it in the proper context for what it is. And those are some of the minor changes to the legislation. But what it's also doing, this is the big one, is to consolidate all the various bits of legislation that criminalizes certain conduct related to children into one act, the Sexual Offences Act. Now, the purpose of this is to streamline the ability of the state to prosecute cases such as this here. It will enable the NPA to put together easier cases when it comes to the prosecution of people involved in the abuse of children. But out there today was Justice Jody Collopin. He's the chairperson of the Law Reform Commission, and he was explaining the rationale behind having a look at these changes to the laws involving children and sexual abuse. Take a listen.
Sexual offences, pornography and children. And it deals with the production of pornographic material involving children, the dissemination of that material. And I think in a growing age of ease of technology, one sees the impact that this could have on the broader society, but also on the interests and the rights of children. And given that our Constitution carries within it the paramount principle that the best interests of the child matter and matter significantly so, it's an important area for us to consider in the context of our society. And the report covers a variety of areas in how the law could best regulate that with a view to protecting children, but also recognizing that children themselves may be involved in the production of this material, as children are naturally curious, and how best to deal with that other than through the strict strictures of the criminal justice system, but in recognizing that we need to deal with children in a way that recognizes their youth, their vulnerability, and the need not to stigmatize them permanently.
So what's the main benefit of this? I mean, currently it's not like there are no laws in the country that could apply to child abuse. But what's the benefit of doing what Jody Collopin was talking about? Very briefly, Barry.
Yeah, you're quite right, Dan. So you've got various pieces of legislation that criminalise the acts that we're actually talking about here. It's already criminalised, whether it be in the Film and Publications Act or in the Cyber Crimes Act. The purpose here is to consolidate that under one piece of legislation. And what it does is it makes it easier. It streamlines the process for the prosecution, for example, in the NPA to be able to put together a case. We can refer to one piece of legislation that relates to the abuse of children.
So when you're in court, the magistrate, the judge, they know which law is applicable in that particular case of the sexual exploitation of children. I understand the Commission also touched on some matters which can be sensitive, like cultural practices, customary practices, like Ukuthwala. What did they recommend there?
Indeed, and you know, we just got to look at the history of this country, the way some practices and the culture of many people in this country was disregarded and not taken seriously. What we're seeing here, Jody Collopin very mindful to say that while there was benign aspects of this particular cultural practice, it has been exploited by some in the modern age. So what they need to do is be able to recognize its cultural origins, but also criminalize those aspects that are being used where prejudices, children, well, in this particular case, this is young women and girls that are being exploited here. So what they're proposing is a piece of legislation, a unique piece of legislation that would criminalize, which is basically the kidnapping of women for the purpose of forced marriage. But Kolopin was again explaining what the rationale behind this is. Take a listen, Dan.
Practice of Ukuthwala can be described in the most simple terms as the forced taking of a bride. And the report recognizes that some features of the practice may have had a benign origin, where a young man and a young woman fell in love and decided they wished to spend the rest of their lives together. But there were obstacles to that happening, either on the part of the family, either on the part of protracted and stalled Lamola negotiations, and so practice evolved, benign in its origins, where the young woman would be taken, not kidnapped, but she would be taken and brought to the family of the young man, and she would live there amongst the other women, and that would create a situation where the family of the young woman would be almost compelled to come and seek her out and to enter then into bona fide negotiations for the marriage to be concluded. But over time, some features of that practice deteriorated to the extent that the notion of consent in some instances simply lacked. People were taken without their consent. In some instances, young children were the subject of the distorted form of Ukuthwala. And following its research and following a request to undertake the investigation, the Commission produced a report which seeks to recognize, on the one hand, the benign and some of the positive features of the practice, but on the other hand, to ensure that the practice was not used to force people into marriage, or indeed was used to prejudicially impact on the rights and the interests of children.
Okay, there were two other reports in addition to the ones that are dealing with this cultural practice of Ukuthwala and how to protect young women from those who are unscrupulous and who behave like this. Meanwhile, they're committing an act of kidnapping, nothing to do with the culture. And then, of course, the sexual exploitation for children, the streamlining. What other two laws was discussed by the Commission?
Well, the proposals that came from the Commission, the one related to prescription. And this has to do with the time within which a person would file a claim against another individual or a company. As the law stands at the moment, there's various pieces of legislation. Again, it comes down to streamlining and consolidation, Dan. There are pieces of legislation that would prescribe that if you want to file a certain claim against a certain person, if it's this type of claim, you have to do it within 3 years or else it prescribes. You can no longer do it. There's other pieces of legislation that would have 5 years, different time periods. What they want to do here, and the term they actually use is harmonizing. So bring it into one piece of legislation and be able to set a specific time that everyone knows that this is it, and you know it's easily dealt with. The other aspect relates to legal fees, and so important in South Africa. We talk about access to justice. Jody Kolopin was talking about being in a constitutional democracy. Well, the doors of a courtroom might be open, but they're locked from a financial perspective for many. The access to justice. So, and he gave the example, somebody might have a legal dispute, but that person doesn't necessarily need a lawyer. What other avenues are available to be able to assist people gaining access, to be able to have a legal resolution to their particular problem? And they're also looking at regulation of certain legal fees. He made it clear it doesn't apply to a big multinational who wants to spend big money on a big corporate law entity, but for the little guy down there at a magistrate's court who wants to address certain things through a legal mechanism, you cannot be expected to overcharge these kinds of people. There needs to be regulations on this, ethical management of the legal services.
Sounds like some good work coming out of the legal fraternity there from the South African Law Reform Commission. Thank you very much, Barry, for that update there.